Hi everyone, welcome to our LA Foyt Foundation's webinar series. Our webinar today is entitled Education Sector, Practical Tips and Tricks. My name is Pam Scott and I'm the Executive Director of Corporate Services here at the IPC, and I'll be moderating the webinar. So before we jump into this webinar, I wanted to let you all know that as participants, you have joined in as listen-only mode. However, please feel free to ask questions in the question pane. We will be trying to answer your questions throughout this webinar, so please don't wait until the end to ask your questions. I also wanted to let you know that this webinar is being recorded, so if you want to refer to it again or let a colleague know of this webinar, it will be posted on our website at www.oipc.sk.ca in the future. Please follow us on Twitter at SaskIPC. We will be sending out a tweet when the recordings for all webinars this week are published to our website. Use the hashtag LA Foyt Foundations for conversations and information about the webinar series. Please take a look at the chat box on your screen for links to resources you may find helpful during this webinar. And I now want to introduce three amazing presenters that are here for you today. Rob Curry was the Deputy Minister of Education from 2017 to 2020. Prior to his appointment as Deputy Minister, he was employed by the Regina Catholic School Division for 31 years, working as the Director of Education, Supervisor of School Operations, as Principal, Vice Principal, and a classroom teacher. Geraldine Knudsen is a solicitor for the Saskatchewan School Boards Association and has been for the past 25 years. She acts as counsel for boards of education throughout Saskatchewan, including advising on LA Foyt. Previously, she worked in private practice for the Public Legal Education Association and as teacher and teacher assistant. And thirdly, we have Clint Redekop, who has worked in education for the past 31 years. He is presently employed as superintendent with Prairie Spirit School Division, and prior to that, he has been supervisor, principal, and teacher. This webinar will be a series of questions followed by answers from our presenters. So without further ado, let's start with our first question. I'm going to hand this question over to Geraldine first, and then Rob and Clint, if you want to add in afterwards, that would be great. So our first question is, what has the evolution of access to information been in the school setting? Well, I'm sorry, Rob. Rob, okay, you were supposed to go first. Here we go.
Thank you, Pam.
Sorry.
Thanks, Geraldine. The evolution of the access to information has been quite interesting. And going back to my own personal experience, having started in the classroom and through to working with the ministry, is to see that evolution having taken place over a number of years to where we have very, very good people working in our education sector who are very, very interested in ensuring that there's a constant and an accurate flow of information for the betterment of the student learning and also for the practitioners so that they can make sure that they're doing their job to the best of their respective abilities. But we also have to understand that we are guided provincially and locally by directions, legislation from the Education Act, as well as the Local Authority Freedom of Information and Protection of Privacy Act, and our school division policies. And so while educators look to inform families and communities based on the good work that's taking place, they also have to appreciate and understand there are guidelines from which we continue to work. And you see there on the slide, again, the three that I've referenced. And it's incumbent upon each and every one of us involved in the education sector to be aware of these legislated acts, as well as our division policies as to what information we are eligible to share openly with our communities, respective communities, or other individuals. And so we do have a duty. And I'd just like to highlight 2 points from these respective acts. So in the Education Act, Section 85 speaks to the duties of a board. And as an employee of a board, and Geraldine will be able to speak to this more in a fulsome way, but as an employee of the board, you are responsible for representing the board in ways that are outlined in the Education Act. Similarly, when we look at the Local Authority Freedom of Information and Privacy Protection of Privacy Act, it speaks in there, in Section 5, that people in the community do have a right to access of information. So it's incumbent upon us to understand what that information is, what those rights are in terms of access, in doing the continued work that we are required to do while representing our board and serving the families and students within our school settings. Geraldine or Clint, can I turn it over? Anybody want to follow up with some comments from your respective ends?
I can dive
Sure,
in. Oh, go ahead, Geraldine.
Clint. No, go ahead, Clint.
I was just going to add some things to what Rob just shared. I've seen in my career a complete access of information being paper-based, and now it's very digital-based. And I'm going through that transition personally. I've seen our ability to improve what we can access and how quickly we can get information to publics that request it. So I just wanted to throw that piece in. Geraldine?
Well, that was, I think, one of the points I wanted to make too, Clint, so I'll just follow off that. Really, I started working in 1995, and at that time, there was actually a section in the Education Act that talked about giving people access to their files, and plus, you know, confidentiality was an understood concept in teaching. But really, LA FOIP came into play around that time, and that was around the time where we started using. I remember one of the people in our office wanted us to use this thing called email, you know, and we were a little bit suspicious at first, but, you know, that was around that time where businesses were sort of adopting that sort of thing. So it's an interesting comment that LA FOIP has sort of paralleled that development as well. And that's been one of the evolutions that we've had. We always were concerned about privacy. And we always were a bit concerned about access, but my gosh, now we have actually, as Rob had mentioned, we've got specific legislation in place that's fairly complicated compared to what was before, that sets out the rules by which we would do these things that instinctually schools knew they had to communicate with parents and let them know what's going on. But we now have rules where parents can actually go to the legislation and do something about it. And that was a bit of a change that took some time, and we still see remnants of that happening, because we've got a situation now where, yes, we've always had to give access, but now it's much, much more open. It's like pretty much everything unless there's an exception. But also the protection of privacy has just ramped up what we needed to do to keep those CUME files that were in folders in the principal's office in a filing cabinet that might have been locked, might have not been. Very different than when we're uploading a lot of student data and sharing that with the ministry and with our constituents, like the parents and students. And so what we've ended up with is a bunch of rules in a time where we've got way more information, but we've also loosened up the boundaries between the school and the outside world. And that overlap of, you know, a student in school might be sharing personal information by going on an app when they're sitting in their classroom. Where's our responsibility for protecting the privacy of that student if we don't even know what the student is doing? And yet maybe they're doing it because they need to do their classwork. Where are the boundaries of where our responsibilities as school divisions lie? And so I think we've also had an evolution in the sort of need to know concept. I think we always understood that, you know, we should share information when we need to know it. That's okay. Need to know right now is a very distinct and much more narrow piece. Again, we had the days and where teachers in a school just assumed that they got to look at any kid's file that they needed to look at. And needed to look at didn't mean a specific purpose. It just means, well, you know, I saw that kid on supervision today. Maybe I should look at his file to see what's really going on with that kid. And there was that concept of need to know was a very broad concept in education because teachers were involved in so many things. Not the case today, a very narrowing of that. But we've also had with the general public to do the explaining to parents. who used to get, every year they'd get that class list and the phone tree, and they'd get everybody's personal information. So when they had a birthday party, they could just invite all the kids. And now we have principals having to tell them, wait a minute, those lawyers down in Regina are telling us we can't do that anymore. And so we've got a lot of people that are running up against what we do. So we've got way more people too coming in and asking us for stuff and wanting to access stuff. But we've also got lots of people that are saying, why are you changing things? Why are you doing it this way? Those are just some of the things that I've sort of noticed over time, but they sort of, some of the conversation we'll have later this afternoon are how to deal with some of those things. How do you deal with the demanding parent that just wants to show up and get everything they have about their kid? You know what, now we can't just do what we used to do. So going back to Rob's comments too about the legislation, we have both these pieces of legislation. If you want to look at employees, you can look at the Employment Act and what kind of information needs to be kept there. If you want to look at employment insurance, what has to be done there, how long it's kept. And policies, every school division that I'm aware of has policies on how to deal with information, how to access it, how to protect privacy. And so those have to be followed. I always tell people, if you don't follow policy, the first thing a regulator or a judge is going to look at, and the first question you're going to be asked is, what is your policy? The second question is, did you follow your policy? So it's a different world that we're in. And as educators, I think, and working with the Privacy Commissioner's Office to educate people more, to spread the word about what the legislation is, how we do it, I think that's a really important part of that.
Thanks so much. And that leads really well into our next question. And Geraldine, I'll ask you to start on this question. What are some of the conflicts surrounding access to information in the education sector, and how do you deal with them?
Well, generally, I mean, I think we sort of talked about some of them, and maybe a good illustration of this is sort of, I mentioned parents before. Probably, especially when I'm talking like with principals or at school level issues, the day-to-day sort of issues, one of the biggest ones that comes up is custody and access. And that might be a good one to use as a sort of starting point to explain these sort of the types of conflicts that can come up in here. And we get a lot of these. Parents that are dealing with custody and access of their children are often fighting about these in court. And so each parent wants certain information from the schools. And when you're dealing with a situation like this in a court, the judges are often looking and appreciate the information from schools because they see the school as a neutral sort of place, and that gathers an incredible amount of information about a student and about their family. So they're looking for that. So you've got parents both wanting the school to give them information and to use that information for their own purposes. And unfortunately, the ones that usually I see are not the ones where the parents are getting on and are really working together for the best interests of the child. The ones that I see, unfortunately, are parents that are smashing up against each other and are pulling at the kid and trying to involve the school in that. So we do have to be careful when we're dealing with those conflicts, because both parents will come in, both parents will either demand that we give them everything and nothing to the other parent. They might come in and say, there's no way my husband's new girlfriend gets to know anything about my kid, and if you dare tell them something, I'm getting my lawyer to sue you. Those are the kind of things that the people on the ground at the school are having to deal with on I won't say a day-to-day basis, but on a very regular basis. So one of the things that we need to do is in terms of addressing these kind of things, is that frontline staff, those people that are picking up the phone, those admin assistants or whoever it is at the local school, has to understand some basics about privacy law. So that's one of the things that I certainly urge schools to make sure that it's all very well to have your LA-FOIP coordinator and your director know about LA-FOIP, but does that person picking up the phone and talking to that irate parent No, not even to confirm that the kid's registered at the school. Like, we shouldn't be giving any information out over the phone. Do they know that? Do they have the words to say, I'm sorry, I'd love to help you, but our policy is that you must do this in writing? If they do, have we trained them in that? I think that's really important. I think in doing these kind of things, we have to, in order to deal with these conflict, and I'm again using any conflict, but using custody and access, is get the information. Ask for documents. Don't be afraid as a school division to say to somebody, you know what, we need a copy of that settlement agreement. You say there's a court order out there. Well, you know what, give us a copy of that court order. If you say that you're the parent and you've been gone for 15 years, you know, give me a copy of the birth certificate. Give me a copy of your identification. Give me a copy of government with photo ID. You know, we don't have to be polite about this stuff. We need to be rigorous about this stuff. So to avoid the conflict, sometimes you have to sort of create that situation where you're demanding information from people. So that's the second point I'd make, and is train your frontline people and gather the information, gather the records, the documentation, anytime there's somebody fighting. And that goes with regard to lawyers as well. Conflict can, because often lawyers are involved in that, and I'll just say some lawyers, maybe not all, tend to think they're pretty smart and know everything, and they can tell other people what they should do, and then other people should just do it. You know, in most cases, I'd agree with that, but we really want to be careful too, that we don't just assume because a doctor's saying it, a lawyer's saying it, give us this information, that we do that immediately. So as I say, conflict often involves outside parties, and we need to make sure that we're telling people and empowering people and enabling people to say no, and to say, no, this is our process. And we'll go back to the, you know, there's the law, there's the policy, and we need to follow it. And a director might know that, but I want the EA to know that when the mom calls and says, talk to my lawyer. I want the EA to understand that they can say no, and that they go and talk to somebody else. So any kind of conflict, I think that's where we have to go. And one of the things that we tell people all the time, another tip, another thing that we need to do, is consider the interest of the child. We only exist to educate the child. And we need to think about that. People might demand all sorts of things from us, all sorts of information. Parents might demand stuff from their children. And remembering that Section 49 of the Act says we can share with parents as long as it doesn't interfere with the privacy rights of the child. So that interest of the child is our raison d'etre. It is what the Education Act is about. It is why we have our jobs, why we do what we do. So in any decision where there's conflict and you got two parents saying, yes, no, give me this, we can always put that lens on our face and say, what is the best interest of the child in this situation? And frankly, what's reasonable for the child will be what a court would look at if there was an assessment, and what if there's a complaint, that will become part of the assessment of the privacy commissioner in terms of looking at the information piece as well. The other thing that often happens when conflict is do what I want, or I'm going to go tell my lawyer, the Ministry of Education, your director, my MLA, I don't know who. There's always that when conflict happens. And you know what, we always say, okay, you know, the right answer to that is please do so. Please go there. I mean, one of the things we want to encourage people in conflict is to go see their lawyer. It's amazing how often that will diffuse things, because they'll find their lawyer is telling them pretty much the same thing we are, because, you know, I'm sorry, there's a law about this. And so that can be helpful. When they go to other places, we've found in most cases, and we'll talk a little bit when we talk about third parties later on, generally the ministry, and maybe Rob could speak a little bit to this about his experiences with this, but I've certainly found that they're pretty good and pretty quick to say this is a board issue and send it back to the board. So never ever be intimidated, and again, I don't know who the you is that's listening to this, but the you should also include those people on the front lines so that they know they're not going to be worried about the fact that, oh, somebody says they're going to sue us. That's not a reason to act. That's really where we need to go. I'll maybe stop there and let the others comment, and then we can come back and further discuss if you like. I'll throw it to maybe Clint first from the practical, and then Rob.
Thanks, Geraldine. What you've outlined is very accurate, of course, and smart lawyers are exactly what I depend on a lot. So I appreciate you adding that in. Another area of conflict for myself is people wanting access to our video surveillance. And it's a board record that didn't exist before. And we have, it's a large record, and you have to have that figured out ahead of time. Privacy impact assessment is part of that work, as well as, having that content auto delete on a scheduled time frame. But you will have outside sources requesting access. And who does the video belong to, and whose record is that, and can you give it to someone without exposing someone else in the video, and that kind of thing. And then there's also records being created by students on their cell phones. There's maybe a conflict in the schoolyard, they're video recording it, they're sending it to the principal, that becomes a record, and who has access to it, and should they have taken that video, and that kind of thing comes up. But I would say that would be our second most common.
The point that I'd like to emphasize here is kind of to springboard off of what was just mentioned previously, is that an awareness of the privacy law. So whether it be your frontline individual, your support staff individual, your school-based administrator, senior administrator, and board members, is understanding what are the privacy laws at their respective level. And so to take any one of these acts and memorize it and understand fully, I mean, we could be there forever, and I'd invite you to continue to connect with the people to help glean understanding from it. But at our respective levels, there's an obligation to understand what is accessible, what is information that I'm able to share. And we will have varying responsibilities and duties to oversee that sharing of information. So that's important. And I'd say the evolution, when we come into conflict, something that's brand new right now is, or has been for the last little while, is our students stepping away from their parents. Students' information saying, I don't want my parents knowing this. And the understanding of the privacy law to share that information with parents or the respective legal support to say, you do or you do not have access to your child's privacy information. That's a new evolution that we're kind of encountering here. So I would say there's an understanding of wherever you are in the education sector, at what level do I need to know what in terms of the Education Act and the Privacy Act, and then following forward with my responsibility appropriately. And so that's where it comes into understand where you are and deal with what's evolving. And I'd say that most recent one, and Clint deals with this every day, and so does Geraldine, are students who have privacy information, and they want to hang on to that. That's not privy for others, even their parents. And that's a really tough one for parents to understand in terms of some conversations.
The point too about knowing the stuff that you need to know, I think partly that goes along with that is not being afraid to ask a question. Like there are, it's the same, but there's no stupid questions. Well, in privacy law, the stupid thing to do is not ask the question. So the worst thing you can do is not check something out. So not being afraid to ask a question up to and you know what, there's lots of times I have to say, you know what, I don't know the answer to that either, but let me look it up and I'll get back to you on that. So I go by that one a lot. I'll give a couple illustrations of the student piece, and maybe Clint, go back to your examples too, but transgender youth is one of the examples that we encounter not frequently, but often enough, where the transgender youth might feel very comfortable expressing themselves at the school, but have not told their parents or have told their parents very little. And we've had the struggle with that. What do we say? How much do we say? And in many of the cases, the answer has been, we don't tell the parents something. And that's a difficult thing for some people to understand, because they think there's some mental health issues. But again, what's the best interest of that particular child? It's a dilemma, and it's a conversation, it's a discussion. But that's an example of where we have certainly given advice to school divisions to say, at this point, given this child, given those circumstances, no, you cannot share that with the parent. And there are some maybe other examples of the student issue. I don't know, Clint, if you want to comment on that too.
Yeah, we do see more of these. I hadn't seen them before in my career, so it is much more common. I don't want to go into the weeds on any one particular, case by accident, but certainly being respectful of children as individuals, just as we are with adults, I think that's a thing to keep in mind and when we're having that discussion.
Do you see many of these sort of independent student issues where kids are away from their parents? They move out at 16 and now they're living with their boyfriend or their boyfriend's parents. I would expect you'd see some of those as well.
None 5 years ago, and a couple in the past few years each year, yes.
Yeah.
Not necessarily moving out with a boyfriend, but getting away from a bad situation or dealing with mental health issues. Yes, those would be common.
And those are good examples of when the parent might come up and say, you better tell me where my kid is. I need to know. She's only 15 and she's in danger. And then we have the kid saying, no, my mom's the problem. She's the one dealing drugs out of the house. And so a big conflict there. And again, our guideline is what's in the best interest of that student, and whether or not that sharing that information with the parent would be an unreasonable invasion of the privacy of the individual. That's the wording that's out of section 49, specifically covers that, and that's for under 18 students. So
maybe if I could jump in here and one further comment, Geraldine referenced this a little bit earlier, but when the ministry receives an inquiry for access to information, and there are very emotional responses attached to inquiries. And so what's been very, very, I find effective is that there has been an understanding between the Saskatchewan school boards, the ministry, school divisions, as well, to kind of where does one connect or fit in this inquiry. So if something comes to the ministry, there have been often times where conversation with the inquirer to that this could go back to Saskatchewan school boards, or this could go back directly to the school division. And that's helped kind of, I think, the flow of communication and also access to an answer in terms of the inquiry.
It just, as the School Board Association, we certainly provide advice to boards, and we certainly worked with boards and the ministry to sort of act as a bit of a liaison and trying to get conversations going, sometimes with outside groups as well that would want or demand certain kinds of information. I'm thinking of medical situations where you have, for example, children with violence, and we want to get medical information. Parents may not see that as the same issue. They may see some privacy issues there. Why is the school needing this? What do they need it for? So there's a ongoing education in the sector that sometimes helps those individual cases, but sometimes we have to work on communication. On this stuff is I don't know. As a lawyer, I like to think the law is the end result, but sometimes the law is the least important part of all of this. Sometimes it's that connection between people.
We certainly reach out to lawyers at the SSBA, Geraldine, and your colleagues, and that's not something I was doing 10 years ago a whole lot, and I find we're doing it a lot, like sometimes every week. And I know as a team, a superintendent team, there's always someone that's working with lawyers at the SSBA, and then we're just one school division. So that's a big part of what we do now.
Well, hopefully that gives some consistency as to the advice that's given on these things, and we're also, though, developing, and I think, Clint, you're a good example of expertise amongst the superintendents out there as well. And people are getting better at, and when I said about no stupid question, so you can ask your superintendents, because there are getting to be some people there, certainly when it comes to the practicalities of things, that know more than the lawyers. I can interpret legislation and work with case law. I don't know a darn thing about the electronic pieces to all of this, or what could be even possible, or what are the dangers that are out there. So I think that there's and I go back to Rob's comment about the necessary intersection of people working together. I think, there's no question that that's been helping everybody.
Thanks very much. That was great. Our next question is, what are the demands put on school divisions by outside parties? And Rob, if you want to start this off, that would be great.
I have a bit of a story to share on this point. It was my first year as a principal, and probably within the first 2 months of my principalship, there was a city police who came to the school, knocked on the door, and sat down and said, "I'm here to arrest one of your students." And I don't remember taking in my admin classes or my education background what one is supposed to do. And this is a number of years ago, what one is supposed to do. So I took it upon myself to ask the police, what am I supposed to do? And the police representative just said, "You're supposed to hand the student over to me right now." I said, "Okay, thank you. Would you mind just waiting here?" So I left the room, went to another room, accessed the phone, and phoned down to my board office and got a hold of the superintendent, and I said, and explained the situation and found out some direction there. That was very helpful. And when I go to, we're not just dealing with, my point being, we're not just dealing with parents coming in and say, I want, and the dynamics of the family. We're dealing with sectors of society coming in and requesting information. And I like the word that's been used earlier, demand, like not just a polite request at times. Sometimes it's a very strict demand. And whether it be from other ministries of government, social services, whether it be from police, whether it be from the Ministry of Health, whether it be from, you name it, just other sports, community organization, et cetera, another parent accessing, the class list for a birthday party or for a gathering. And so we have a number of entities within our communities that are coming in and wanting to access information in a school setting or in a school division setting, because there is this congregation of students and of families, and it's perceived that this information is readily available for the benefits of others. And so I would say that we do have demands being placed on not only the frontline workers within schools, the support staff, as well as the school-based administrators, classroom teachers, and on and on. And so I say to the point, then we go back to what we had at the very beginning, is understand the privacy laws, at least generally, and specifically at the level at which you work. And I know that school divisions, as was referenced earlier, as well as the Saskatchewan school boards, with Geraldine's help and others, is helping educate and provide learning opportunities and education opportunities for school divisions, for individuals who work in the education sector, so that they can do their work as it is meant to be.
Well said.
I think it's that's a general comment, and I totally endorse that 100%. And one of the things I think that we need to think about that might help is who's the third party and who are we really talking about. And I think that's important to understand two of the words that are used in privacy law and in the statute, and those are use and disclosure. And when we talk about using information, using records, we're talking about within the school division. How are those records used within the school division? When we're talking about disclosure, we're talking about how are those records disclosed to other people outside the school division. When we're talking about access, we're talking about the individual accessing their own information. But use and disclosure, use within the division is we need to control that. We need to talk about how that's done. And we're going to talk about that a little bit later on here as well. But disclosure is really what we're talking about when we're talking about third party asking, demanding information. And that is the one that you start off with the presumption that you don't give any personal information to any third party. That's the rule. That's the default position. And the only time you can give to somebody else is if you've got the consent of the individual, or you can find a section of LA FOIP. And you tell me if your EAs can tell you what section of LA FOIP they can use to disclose information to the police. They don't know that, and they shouldn't have to know that. But they should know that if it's not an employee of the school division, and if it's not, they don't have a written consent from the individual, they should not be giving anything to anybody. And I think we need to really drill that in and start from that fundamental thing of disclosure to third parties is nothing. There's nothing that goes out that door unless we've got something. And misinformation, when Rob talks about demand and using that word, that is, I mean, the pressures that can be put on these people and police. Your example, I'm sure if there's any principals listening, and Clint, you may have had a similar experience when you were in the school. I've heard that story over and over and over again. And when you've got that, 6'3" police officer with a gun on his belt telling you that you have to listen to them, it's pretty damn hard to say no. So one of the ways to say no is to say, let me call somebody, and then you come back and say, oh, our lawyer said that you can't do this, and whatever. So sometimes it's helpful to those people on the ground to have that policy to refer to and say, oh my God, I'd love to help you, Sam, because you've been great at the school, you've come in and talked to the kids, but gosh darn it, central office has these rules, and if I don't do that, I'm going to be in real trouble. So we need to empower again those frontline people so they can say no when those demands are made. Another point I think it's important is to say that, and again, it's been referenced before, third parties include lawyers, third parties include doctors, third parties include social service workers. Third parties include the police, third parties include the Ministry of Education, because the Ministry of Education, somebody phones you up from the ministry and says, oh, we hear there's something going on there, tell me about it. There is nothing that allows that individual ministry official to get that information, that specific information. There's lots of times we can share information with the ministry. There's lots of stuff in the Education Act and in LA FOIP that allows us to share it. But again, default position is you don't share it unless you can point that section out to me. And when that person's calling up, that's not when you do that. So I think, again, to understand the breadth of who is a third party and that disclosure to them does not happen. And then I think it's important to talk about the individual types of exceptions. And the police is one of them. There is an exception right in the act that we can point to that says, here's the time when you can disclose to the police and you can exercise your discretion. And we can talk about that. We can have people trained in a school division, whether it be principals or superintendents, your LA FOIP coordinator, who can become familiar with that, who can look at the cases on that, who can look at the description, who everybody can call and say, police are here. Is this one of those times when I can share? Right. And I think, Clint, one of the examples might be the video. I don't know if you've had that situation come up with police or not, and sharing video. Yes. Like maybe I'm speaking.
We have a lot of interaction with police. It's mostly all positive. And there are times, I mean, if the police were to arrive at the door and it wasn't to arrest a student, but to inform you that, there's a child with a gun in this school, or something of that effect. So what I always leverage first is safety the issue? Is safety of any of the students in this school the issue? And if that is, then that trumps. We first deal with that. If there's an abduction, we've had that as one of the scenarios. And of course, video surveillance is flowing quickly. We do not need any other confirmation. Let us find that child. Who took the child? So safety is the key word there. And I don't need to read a lot of legislation to know when or when not that would be the case. And so, but then what you said earlier, Geraldine, I think is really, and what Rob demonstrated, he paused. He didn't say, oh my gosh, it's a police officer, where's Jimmy, and go get him. He paused, he went to another room, he made that phone call. So if it's not safety, if it's not an emergency, then seek other voices and your superintendent and the lawyers and get that advice. Take the time to do it right, because there definitely are ways to do this wrong.
And children in need of protection would be another example where there's some legislative authority for police and social services to ask for access to children under those pieces of legislation. There's some very specific times, but yeah, pause, become informed, get the answer, and then proceed instead of just making those assumptions. So I think that's so important. And again, empowering staff. Have I said that enough times yet? But empowering staff to say no and to say, we got your back. If you say no and you tell us what you did, we will back you up on that. But check with us first, on that, or check with us maybe second. Say no, call us. We'll back you up on whatever the decision is to be made. So I think that's an important piece of that. Just wondering, are there any questions yet, Pam, or is that you'll let us know?
There aren't yet. No. Audience members, if you have any questions, just again put them in your questions pane, and we will answer them for you as they come up.
I
So
think
we'll
it'd be
move
a
on
lot.
to
Sorry,
Sorry.
be easier to answer them as we're sort of going through this and give the example.
Right.
Yeah.
Exactly. So going on to the next question, Geraldine, can you demystify the process of a privacy breach investigation for us?
This is an interesting topic because I thought, well, I'll just check. I was thinking, well, I better check which section. I didn't look through the table of contents. So I go, if you look in the LA FOIP, there's the word breach is not found in the LA FOIP. There's nothing that says anything about privacy breach. That's not what the legislation talks about. It talks about unauthorized use or disclosure. That's really what we're talking about there. Which I thought was interesting. I never actually consciously thought about that before, that it's really not a term that's a legislative term, but it's a term that we use to talk about breaches and how to deal with them. And there's certainly lots of good information about it. So again, just want to highlight the difference between the word use and disclosure, because there's two different aspects of what happens. Because if you look at 28.1, which is a relatively new section in the Act, it talks about the unauthorized use or disclosure, and it talks about of personal information. Okay, so we're talking not about just a third-party corporate plan. We're talking about personal information that we're talking about here. And remembering that there's other sections in the Act that talk about when you violate the Act, when you don't comply with the Act, there's offense sections that cover both collecting information, using information, and disclosing information, and talking about all kinds of things. When we come to talk about unauthorized use or disclosure, you notice the word collecting is gone there. We're just talking about use and disclosure in that section, the breach section, if I can call it that. And it's talking about unauthorized disclosure of personal information as that's defined in the Act. And that if it's if you believe that in those circumstances that there's a real, and I'm just going to read it, the real risk of significant harm to the individual. So that's what we're looking at, personal information that's used or disclosed, and there's a reasonable risk of significant harm to that person. And the harm, the case law and so on talks about the harm can be a whole variety of things, and that can be financial, it can be identity theft, it can be physical danger. What significant harm is pretty broad ranging. If those circumstances exist, then you have to take reasonable steps to let the individual know. That's what breach is. Use, disclosure, personal information, real risk of harm. Then what do you have to do? You have to let the individual know. Notification is the real key there. That's it. There's nothing that says you have to let the privacy commissioner know. There's nothing that says you have to let anybody other than that individual know about what's happened. It's pretty simplistic in what the wording is. In the actual dealing with a breach, it's very different. What I find from people when I get the call, oh, something's happened, it's usually, oh, I gotta tell you, this is really difficult, but this is what's happened. There's an emotional component to this. People get worried about what's happened. I think we've seen enough in the news and things about data breaches and significant personal information being exposed, certainly here in Saskatchewan. The issue with health records and not knowing whether your records are just exposed or not. We have some kind of a visceral human concern about that. And then as school officials, there's always a concern about, oh my God, this is going to hit the paper. We're going to be vilified in social media. We're going to have all sorts of issues. And then there's the cost issue too. What do we have to do? You know, what's going to cost us? So this can be a very difficult thing for individual superintendents, boards, directors to deal with because of those far-reaching ramifications. But remember again, when we're talking about the mandatory piece of it, it really comes down to that 28.1 and that notification, and you have to meet all those criteria to that. So there's some really good materials on the Office of the Privacy Commissioner, the website, and if you haven't gone to the website before, you know, write this down in big block letters on your nearest notepad or whatever you're using, go to the website. There is a multitude of materials, both for people wanting to access and for people that are having to deal with access. There's also some privacy stuff. There's links to other places. So, you know, and go there. And there's some good materials on what to do if there's a breach. But to simplify it and to talk about it, I was thinking about this, and how do you sort of think about this? Well, I was thinking that if you're really going to talk about it, what are you going to do with a breach? Isn't it just like, what if you had a plumbing leak or a gas leak in your house? A breach, so to speak. What would you do? Well, first thing you're going to do is figure out what's going on. Where's the leak? What's happening? You know, where is it? Second thing you're going to do, you're going to stop the leak, right? You're going to stop it from happening. And then you're going to try and figure out, well, okay, well, what happened here and how can I make sure this doesn't happen again? And then you're going to look and say, okay, if this was just a washer on the tap and I know how to fix the washer, oh, I can do it myself. But if it's anything more, you're going to get an expert in. You're going to get somebody to help you. I mean, if it's a gas leak, you're going to do that. And if it's a gas leak and it could harm somebody else, aren't you going to go tell your neighbor and make sure that, you know, they or you're downstairs, if you're in an apartment, you're going to tell people that if this breach, this leak is going to hurt somebody, it's going to drip through the ceiling and wet their carpet. Isn't it smart to get in there and tell them this is what's happening? So if this is not science or complicated legal issues, this is, what would you do? What's common sense dictate? And really, if you look through the materials on the website about how to deal with a breach, it's pretty darn simple. Figure out what's going on. Stop it from happening any further. Fix it so it doesn't happen again, and then let anybody know who needs to know if there's going to be some harm to them. That's basically what we're talking about when we're talking about how to deal with a breach. And we can put little curly cues on it and add a few bits and steps to it, but that's essentially what it is. It is not rocket science. It's about protecting your people, your students, your staff, and protecting others should you need to do so. And that's basically what the legislation says, is if it's going to harm anybody else, you best tell them about it. I mean, do we really need legislation for that? Well, I guess we do. As school divisions that take care of people, maybe we could, you know, think that we would do a better job, but we have the legislation, we must comply with that. We're talking about the expert advice. I have helped to worked with several school divisions that have had breaches of varying kinds, from, you know, laptops being left behind, from physical papers, you know, being in a stolen car, to significant electronic breaches. In so far, it could change, but so far, all the times where they've called the Privacy Commissioner's office and said, could you help us? They've had positive experiences with it. They've had advice that's helped them. They've also been able then to say, if the parents, you know, when they're sending out a notice to if they have to send one out, or if they have a parent call up and say, what the hell is going on? One of the things you can say, and this is a bit self-serving, but it's sensible. We are working with the Privacy Commissioner's office. We have advised them. You know, we are working on this matter, and that's not a bad thing for a school division as a public entity to be able to say. Is that yes, we're taking this very seriously. We've actually reported it to the Privacy Commissioner's office, and we're taking advice from them as to how to handle this. The other thing that in the major breaches that we've seen happen is there are times where you maybe don't have a Clint on your staff and you actually need somebody who knows a little bit more about your system and about what could happen and where things could go wrong, and you need to hire somebody to come in and help you do that, to patch the system. There's a report about the Regina Public system that had a breach a couple years ago, and there's a Privacy Commission report on that you can access. All the reports are up and available on the Privacy Commissioner's website. And if you go through that report, you'll see that they had to work with Google to sort of rectify some of these situations. And so you can see that sometimes there's some really technical challenges in actually fixing that plumbing leak. So you may have to hire people or contract with them to do that, but don't be afraid to do that. Again, as you would with a plumber, you're not going to fix a gas leak on your own. And if you do, you deserve everything you get if it goes wrong. So, you know, again, be open to asking questions, getting people involved. And frankly, I mean, maybe this takes the plumbing analogy a little bit too far, but you're going to have the number of your plumber handy somewhere. You're going to prepare for that. You're going to, if you've had any issues before, you're going to know what to do. But in a school, maybe just to move away from the analogy, you should think about breaches before they happen. You should think about, first of all, preventing them. How do you educate people? How do you tell them what they can and cannot do for within the system? And then have you worked with your IT? And I see this a lot where you've got IT and superintendents and teachers clashing. Teachers want to do good things, and those damned IT people always putting restrictions on us, all this privacy malarkey. We just want to get kids out there and using all the great stuff that's out there. We hear that a lot, but you need to have those conversations before something actually does go wrong. And I think too often it's easy just to say, well, we'll just deal with that if it happens. So I think that's, oh, I mentioned earlier the use and disclosure concept. And I think that's an important piece to think about when we're going through 28.1 and about the notification of the other people. Because if you're going to have some danger, the assessment of whether there's a real significant risk of danger, if it's a use, okay, within your division, so the wrong person has looked at the information, the chances of some significant harm occurring are probably much reduced, because you can find that out, you can discipline that employee, and a lot of times it can be an inadvertent breach where the employee says, oh my God, I know I shouldn't have this, and you shut it down right away. And you know, that sort of, you put the extra person on the email, or you typed in K and you sent it to Karen instead of to Kevin. Those kind of things can be easily dealt with within the school division because they're use issues. You have control over those employees, you can tell them what to do, and you can control that information. So less likely that you're going to have to report to the individual, well, Karen got the information instead of Kevin, but Kevin, you know, as soon as Karen got it, she deleted it. Do you really need to send that out to a parent and tell them? Probably not. There's no significant harm. But however, when a disclosure happens outside, say when that employee gets it, they then send it outside to a third party, or the disclosure is to Kevin and who isn't an employee of the school division, that's where you have to really assess whether or not there's a significant degree of harm. So that's enough for me. Just trying to get the legal piece on that one. Clint, Rob.
Sure. Do you mind if I share my screen, Geraldine, at this point, or?
Yeah, you go for it.
Okay, just to speak to what Geraldine was saying there, can you see the privacy breach report template I have on the screen? Great. So this has been taken from the YPC website. We've adapted it a little bit for our school division, but you can see it summarizes what Geraldine was saying and kind of answers the question, like what's involved. So you can see what happened, when did the breach occur, when did the public body learn of it. You can see down below the piece about harm, a real risk of significant harm to the individual being, you know, the important factor to weigh things. So having this available to our staff on our all staff portal, we have this guide available to them as soon as there's a privacy breach, and a poster to keep nearby that basically says privacy breach occurred, report it. I mean, that may not be the first thing in what Geraldine just said, but we're more thinking like it's a gas leak, right? So report it right away. There's a gas leak in my house. contain the breach, so let's stop it right away as quickly as we can. The notification of those that are affected, if there's harm, then we need to notify. And then of course we need to change our practices so that this doesn't happen again. If you don't mind.
Clint, your point about the report, I agree with that 100%. You should never deal with it individually. The report to your supervisor, that's a great point. I agree with that point. Thank you.
If you don't mind, I'm going to segue this one into the next question a little bit about sort of, has there been an increase? Pam, do you mind if I do that? I guess I'm taking liberties here, but
go ahead.
Since I have the screen right now, I wouldn't mind mentioning the pieces that we've been dealing with around privacy breaches in my 31 years. And I remember being a young principal, and the principal at the school division next door accidentally at the end of the day quickly wanted to send a note home and grabbed a piece of paper. Rob and Geraldine, you might remember this one. He grabbed the paper off the secretary's desk, wrote something to mom on the back, but didn't pay attention to what was on the front. And it made the news and it became a problem. And it was my first exposure to a privacy breach as a young principal. And so I've seen it happen since then in other ways. The teachers, back when the web was new, they would put things in their web folders, thinking that no one could see them because they didn't put it on their web page. They just put it in the folder. And that was the second time I saw privacy breaches hit the news in Saskatchewan in education. And I remember it very clearly. And it was when I took over this responsibility, it happened 3 times under my watch in the first year. And it was something we had to make really clear that search engines scrape everything. If you put it on the web, but just because you didn't make a link to it does not mean that other people won't find it. And so that was interesting. The whole faxing to a wrong number. We don't use fax in any of our schools anymore. We removed them 5 years ago, but faxing to a wrong number, that's quite typically you get health information in faxes, and quite typically that can get sent to the wrong place. I have a few bullets if you don't mind me sharing the others. What's happening nowadays, a lot of mass emails. We're getting people who are in a hurry to send things, and it's not just to one individual, it's to a whole group. We've actually had the whole city of Warman receive something through a mass public alert system. And that was, could have been way worse. So things to caution about, be very careful when you're selecting recipients, whether it be in your mass alert system or in your email. It's very easy to have a privacy breach happen every single day because of that. We're just not being careful enough. You have to stop before you hit send and take a look. Are these the right recipients? Please do that. Inviting the wrong person to your Zoom call, that's one thing, but you invited the right person, but now they're done and they're supposed to leave, but you did not remove them as an attendee. So they're not on screen anymore, but they're still viewing the chat. They may even still be listening to the board chair speaking. That kind of thing can be a quick privacy breach and very common to our modern time. And then finally, phishing credentials. This is the one that I think is happening a lot and is not getting reported because no one's aware. This one I want to bring to everyone's attention. It's happening worldwide. And so you get that link in your email. It says, free McDonald's coffee for being such a great teacher during COVID. We want to give you a free coffee. Just click this link. You click the link and it goes to a site that looks like McDonald's coffee. But weirdly, it asks you for your name and password. That should be a big red flag for you. First of all, should you be getting McDonald's coffee advertisements in your work email? But secondly, should you be putting your name and password in after you've been offered a free coffee? And that's happening. And so we test our users, and not to embarrass Prairie Spirit, this is, all organizations are doing this now, sending out these types of emails to their users to see how many will click the link and then how many will put in their credentials. And I can guarantee you, if you haven't been testing your organization, about 43%. And if you keep doing it for the whole year, it'll get down to about 18%. But 18% of people who've been tested repeatedly, a monthly basis, still put their credentials in, means that this is why I think that there are people who've given their credentials away and don't know it. And then what we know about ransomware and phishing, the perpetrators don't immediately expose you. They live in your account for a year to a year and a half, typically. That's the new information just this week. BBC Tech Guide, if you want to see where that's at. And you can see they live in your account for a long period of time looking for other ways to use that information. But that's, during that whole time, that's a privacy breach. A privacy breach of a very high magnitude. It's everything in your files and folders. And so how do we mitigate that? And there are a couple of ways. First of all,
Clint, before you go on, so when you say everything in, so does that mean that if they access a teacher or director's account, they could actually get into all the student accounts and things that
they would have the same access that person has.
Wow.
those credentials would give, and with no one's knowledge, right? They log in the same as you. So there's a couple of things happening to mitigate that now, and I want to give that to everyone. First of all, from a user point of view, you should have multi-factor authentication on all of your important accounts in your life, from banking to your work. And if you don't, please talk to your tech department and get that enabled. I still am writing letters to CIBC because they're one of the banks that doesn't do that yet. So they prefer to use email alerts, they say. But it would be way better if, rather than just putting in my name and password, because I gave that away in that McDonald's coffee email, that they would need a code off of my phone to also get in. And that will reduce your attack face by almost 100%, because they don't have your phone, they don't have the ability to get that number. There are some people getting around that now. I won't get into that. I can get into the weeds on how even your phone can be fooled in that sense, but almost 100% foolproof, multi-factor authentication. Get a code that comes off of the application when you log in, so that not only your name and password are required, but a code is also required. And then what that does is that means then the bad perpetrator is not getting in your account. Secondly, IT departments, to protect data, you should be deploying the new industry standards of alerts. And that means whenever there is strange or funny activity on a user's account, that is suddenly they're logging in from Holland and then tomorrow they're logging in from Saskatoon, the system should say, what's going on? Geraldine's logging in all over the world. Is she like jet setting now? And she may be, or she may be using a VPN. But if Geraldine doesn't normally use a VPN and she doesn't normally fly around the world, then the technology should alert me that weird things are happening with Geraldine. She's logging in from all over the place. And I get those emails daily. And if they say high risk, I trust them. They're almost 100% right. High risk means that person was indeed compromised. That happens about, in the last 12 months, 3 times in our organization. That means they clicked on the McDonald's email, they gave up their credentials, and now there's someone living inside of their house and they don't know it. Creepy. And that's my little piece on the phishing credentials. So I also have a screen share for the next question, but are there more questions based off of that? Or does someone else want to comment? Sorry.
Maybe if I could just add to this this last little bit. What we're living through right now, and I know from my experience when I was working with the ministry, was COVID. When COVID presented itself, there was a significant conversation about what's the Privacy Act, what's the responsibility of school divisions following their own policies, as well as the Education Act. When there is, and I'm sure that all of our participants here are aware, when COVID started happening in our province, there was not a Sally Smith over here in such a community has COVID. It wasn't naming the person. There was significant interest from the public to understand where and who and how. But there, as we're going back to, there are privacy, there are legislated responsibilities that we are to follow. And so you will have noticed an evolution that what started in the COVID world was there was something in the province, and then it went to their different regions, and then their identification of schools. And that was kind of a step-by-step evolution that took place. And there was an impetus and there was a pressure on that, because I'll also speak to this one. There were social media postings of the situation before the legislation could be, or aspects of the legislation could be enacted to inform the public. And so when we talk about have things increased, absolutely. There are sometimes that there's disclosure of information through postings of social media, and the information's out in the community, but we have our legislative responsibilities to follow from an education sector point of view, and we will be held accountable to those.
The stuff Clint talked about scares the heck out of me, and I don't even understand half of it, but it scares me, and so if it scares you, you need to talk to your IT people, you need to inform yourself, you need to learn this stuff. Why? Because, well, it's good and you should do it, but from a legal perspective, one thing we didn't mention, because it's a different piece of legislation, is something called the Privacy Act. Plus, there's also been some case law that says there's now a tort of a breach of privacy, which means that there's some actual financial and legal liability if you don't protect privacy. And when you hear Clint talk about, well, you should think about this, that, and the other, if you have a big breach of privacy and somebody is harmed and they sue you, they can do that under the Privacy Act or by the tort of the breach of privacy. One of the questions that you will be asked, well, as I said before, do you have policy? Have you followed the policy? And then what protections have you put in? Did you know about things? Did you investigate this? Did you do any homework on how to protect this privacy? I tell people all the time, school divisions probably have the most information about a child than anybody else, whether it be social services or justice, because we collect all of that information plus the education stuff, plus kids will tell teachers stuff they won't tell anybody else. So the standard of care to which we will be held as school divisions in terms of protecting that and preventing breaches will be very high. And so you will be asked, what did you do to protect that? What did you do technologically to do that? What did you do physically about that? And what did you do in terms of your policies, procedures, your audit flow, all of those kind of things? You will be asked that in a court at some point if there is a significant breach. Now, that's always not always the best reason to do something because you're scared of being sued. On the other hand, it's a good thing to do just from a moral, ethical perspective as well. But there is that legal punch as well that you should be thinking about.
I don't mean to scare people. I hope I also offered.
It always does.
with MFA and with our, the current tools that we have as IT staff, we shouldn't be afraid. We should just make sure we're educating and making everyone aware and doing a good job training. We need to get better at that, I think, how to train large groups of people. We aren't great at that yet.
It helps me understand how sometimes people say when I talk to them about the law, it scares them. So it's a good experience for me to hear that from the other direction.
We do have a question here, and I apologize for the audience. I wasn't able to get some of the previous questions. We will ask those at the end. It wasn't coming up on my machine, probably a user issue. But we have one here that I will ask. Considering multi-factor authentication for school division staff, any advice or tips for overcoming the pushback? Inconvenient, etc.
Right. Yeah. So people, there's a couple of things. It's inconvenient, but it's only going to ask you for the code if you're logging in from a new location. So the first time you set it up, you put a code in, and then you live quite comfortably for whatever length of time you allow people to live without having to revalidate, so long as they're coming from the same place. But as soon as they go to a new browser, computer, or geophysical location, it should challenge you and say, what's your code again? Just want to make sure it's you. And so that's how that works. So it's not like they have to put it in 9 times a day or anything. If you're always working out of the same building or in the same region of Saskatchewan even, it's not going to bother you for 90 days probably if your IT sets it up that way. Does that help?
And also the big advantage that employers have is, yes, they can try and work about pushback and all of that, but ultimately an employer can say, thou shalt do this, or you will be disciplined and you might lose your job. I mean, not where we want to go, and not the greatest start for an HR thing, but ultimately as an employer, you have that right. And if that's what it takes to ensure the privacy and safety of your students and staff, that's how far you can actually go.
And we do get some pushback as well on using phones. Some people say, I don't have a cell phone, or you don't pay me to use my cell phone. You can get around that using an app. And an app is actually more desirable than a cell phone anyway, because a cell phone can be, stolen, or at least SIM swapped, which is a whole different tech term. But essentially, you can use something like Authy or Google Authenticator or Microsoft Authenticator. These are industry leaders in this technology, and it's used everywhere. You can MFA your Twitter account, you can MFA just about everything you log into, so no one else can steal it from you. And if you listen to the hacker blogs and podcasts, they go, I don't even waste my time. If it's MFA'd, I'm going to go on to the next person because that's just too hard to get around.
Excellent. So I think what we'll do is we will ask our last question, and then I'll go back to some of those questions that the audience had. So our last question is, what are we doing to protect student data? And Clint, I'm going to ask you to start off with this question.
Thank you. And I'll try to be brief. This is my big area. I've presented this in the past when Geraldine's asked me to. So at Prairie Spirit's website, this is open to the public. So I just want to show you that you can get to this and use this if you wish to. There's an area called protection of student data. The address is right here at the top, spiritsd.ca/trusted. Can make that a little larger if that helps people. How's that?
Good.
So what we've done is we have worked with third parties to sort them. I know they probably don't appreciate being ranked, but this is for the protection of student data, so I'm certain we can all get behind it. So we have level 1, which means that the board has sanctioned the use of these products. At a trusted level, we have a non-disclosure agreement with these parties. We have also been allowed to openly scan them for any exposure that they may have, which has been really interesting. We have helped just about everyone on this list on a technical level to say, you're exposed here, here, and here from an educational point of view. And it's not something they care about or worry about, but these, to the credit of these companies, they now do. And I'm really thankful for that. Some great stories there, and I won't go into them. Geraldine's heard them all, at least some of them. And then we also asked them to provide us with a service organization control report, which was something that was introduced by the Barack Obama administration. It's basically an audit of all of the data interactions on our data on their systems from a third party. It's kind of like a financial audit, but it's a data audit. It's an expensive thing for an organization to hold. So there is one company in this list that we do something different with, and that's, I won't get into who. So then if they are not level 1, we need consent. And what Geraldine was saying, we don't do anything, we don't share data with anyone without consent. And so we have a long list of services that we have done this open security scan with, this OSS process. This is a white hat hacker process that one of our individuals has taken all of the training and continues to be trained on. So we do that with all of these. So we don't have an NDA with them. They don't provide us any reports, but we've checked them out and they seem to be solid from that point of view. And so there's a long list that's grown over the years. Teachers will email us and say, how about this one? How about that one? And you can see it's really gotten long. It's gone from 10 to I don't know how many now. Then there's the level 3s. And the level 3s, we've approached them all. We've asked them, would you please improve your security? You're not, your systems are basically sharing data that we don't think is appropriate. And so most of these organizations say, thanks for letting us know, but they kind of make their money from that. They make their money from sharing your data. And so they aren't interested in going further than level 3. We have had people in level 4, or vendors rather, not any at this moment. We've had 2, and I won't say who, but I'll just let you know that they were completely taken over by hackers. We notified them, we showed them screenshots of their servers, with the hacker materials. One was actually running a hacker store where they were selling materials for the dark web on their server, and they didn't know. And so we helped them with that. And so all of that is achieved with this OSS scan. It's basically what every other server or computer can see when it talks to another computer, but we can't because we're humans. And so it's interesting. So people see each other and they go, oh, you're wearing clothes today. Yes, I'm wearing clothes too. Good job. But servers, you don't go, oh, you're not wearing any clothes. I think I'm gonna take advantage of that, or I'm gonna come in and take all the stuff you have on your desk because you're not guarding it. And so people don't know that by talking to an app or a server or a computer, but with this process, it does it really quickly and it finds out whether or not they're being secure. So that's the first thing, is we do that with all of our vendors. Secondly, I was going to show everyone a point of exposure that's sort of come to light in the last 2 years. And there are organizations on the web that are bringing this to light. Firefox is one of them. They are very much in favor of privacy. And since this is a talk about privacy, but it's really about LA FOIP, but so I'm going a little bit too far here, but I really want to share this, so I hope you don't mind. So when I go to jamieoliver.com, and I love his site because I get great recipes there, I noticed something this past week. You might have noticed it too. You go to the websites and they say, please accept our cookies. And you go, okay, whatever, I'm accepting your cookies. And accepting your cookies used to mean, I'm gonna let you know what browser I'm using. I'm on Safari or I'm on Firefox or whatever. And I'm gonna let you know which country I'm from. And that's all they used to collect, my country and my browser. Well, things have changed. So it says, you have the right to object to the use of the cookies on this website by hitting reject all. I cannot find the reject all button anywhere, guys. But there is an accept all button. But what's really great, what Jamie's done here, and I really commend him, or whoever runs his website, he says, I'm going to tell you how all your data is used. I'm going to tell you where it's all used. And so here's how it's used, all these purposes. We'd like to, get some access information on your device. We'd like to select basic ads for you and so on. But it gets it gets way, what's the word, much more in depth than that. We'd like to see your precise geolocation data within a few meters. Is that okay? You know, do you need to give that to Jamie Oliver? Do you need to give that to, here we go, I'm going to show you who he's going to share all of this with, not just with his own people at his own tech site, but he's going to make a ton of money sharing all of this data about you with all of these businesses. And yes, do you see this little scroll bar? All of these businesses. And each one of them is listing here what they're going to take from you, all of them. And I'm just beginning to think, this is a valid, you know, someone being transparent, saying, I'm going to share all of this data with all of these places, but where am I going on the web that's going to just take my data and not ask me? And so things like my last control copy, for instance, you ever hit Control C to copy something? That's a cookie, it could be taken. So what's the last thing you just copied? Go to your URL and hit, I'm not going to do it, but I might have a password in there, but hit Control Paste somewhere, Control V, right? Or if you're on a Mac, Command V, and just paste the last thing you copied. Are you okay with them having that? Or how about the last 5 websites you went to? Or how about the last 6 months of websites you visited, and so on? Or what if some of them are even, can I have access to your network? So what about what's going on in other places in the house? Is that okay? And you're actually sharing that just by visiting a website. I find it remarkable. Check it out for yourself. I just want you to know that cookies are potentially a privacy breach issue. And there might be some questions on that, but I'm getting far too far away from LA FOIP, so I apologize.
Well, not really. I mean, some of this kind of stuff, like I know there's digital education for students, for example, because I think of a student using this in a school, it's scaring me now from a legal perspective. Like, so we've got kids and we say, okay, do some research on this issue. So they're doing some research on computers in the school. And so they're sharing their stuff or the stuff of the last person on there. Are we educating kids about this? How do we, like, there's some real significant issues here. Yeah.
I'll stop
I don't
sharing.
know the answers.
Okay. That was very informative, and I want to thank you very much for the webinar today. We do have some questions here that I'll ask, and again, I apologize that they weren't asked earlier during the webinar. One of them is wondering if the employer has to notify the employee as third-party notice as per LA FOIP if the employer has received a request for the employee's employment contract.
There's nothing that I'm aware of specifically in the legislation that requires you to let anybody know about it. In fact, that may be personal information of the person requesting it. But I can tell you the employment contract is, there's a specific section of LA FOIP that says that the terms and conditions of employment are not considered personal information. Therefore, if a request is made for an employment contract, the answer would be, it's not personal information, therefore we can share it. If there are elements of the contract that would reveal personal information, like whether or not they're getting the single or the married pension or benefits plan, that may be redacted from it. But specifically the question about the contract, no, they wouldn't be notifying because it's not even personal information. If personal information of an employee is requested, depending on the nature of the request and what's being requested, there may be some ability, I won't say obligation, of the employer to actually tell the employee that the request has been made. But again, the employer is faced with protecting the privacy of the person who made the request as well. So it's not a straightforward answer. But generally speaking, when we get requests from, let's say, external bodies like CRA, for example, or people that want to garnish wages, we would normally suggest that you say, is there any problem with us letting the employee know? And generally the answer is yes, they know already. So for those kind of things, which would be the most common requests, telling the employee would be good practice if you're able to do that.
Thanks, Geraldine. The next question is, what is the rule for videos? Do you have to keep or should you erase immediately? RCMP will ask for the videos if charges are being determined.
Quickly on the legal one, it's a records retention. talks about that. So the question is, how long do you need to keep them for the purpose for which they were created or collected? That's the general answer. Maybe Clint, you can talk about the practical answer, what your school division does as an example. There's not a specific right or wrong in terms of how long. It depends on the needs of the particular school division.
The guidelines that we followed from LA-FOIP, I think it was from LA-FOIP, from the lawyers that guide us through LA-FOIP, basically was to have a data retention policy. And so we looked at how large the hard drives were in these video surveillance systems and that they would hold data, it seemed like, for about 30 days. So we set our policy to be 30 days because it then begins to overwrite the old data. And then when those two match, then you take away the hard work of having to go around deleting things.
And if you do need to take out a section of video because of a particular issue that happened, then that piece that you kept or collected may be retained for much longer. Let's say it's used in some litigation that the board's involved in, that may be retained indefinitely or for many, many years. So depending on the use that's being made of it, when the use changes, then the retention period will change as well.
Okay, the next question. The need to know in an alt school setting, given there's multiple staff members who may be providing support to the student, is it permissible to share that information with those staff members? Would we have a different expectation in some senses given our context?
Rob, maybe you want to start with that in your experience of sharing within schools in the past?
Yeah, maybe I'll just start. Thank you for the question, a really good question. And I would defer to, there are often different interpretations of need to know. And so you as the person leading this sharing of information need to really sit down and understand, for what purpose does anyone need to know that information? Even if the other individual requesting it says, well, I need to know to do my job. Well, you're going to have to determine whether or not they can do their job while not knowing that information, and the safety of those involved will be respected. So I would say that interpretation of need to know is one discussion you will probably have with a number of people, and also then doing your due diligence to understand, does one need to know this in order to ensure their job is attended to appropriately, and is the safety of the individual involved, their individual information, respected in your ultimate direction.
Boy, that's the practical common sense interpretation of the law, and I like that, because it is situational, but it is not dependent on personal perception. It is a discussion, and it is not black and white. Yeah, that's great.
So our next question, questions in regards to schools collecting information. When registering children for school, it is mandatory to provide the child's health services number. I understand the purpose is for if the school has to contact a doctor or hospital, but is this information, sorry, I've got to scroll here, but is this information a real need to know? Paramedics, hospitals can still provide immediate care without that information, and parents could provide the HSN afterwards. Just curious as to what your opinion is on collecting that personal information.
We are very clear that this is not something that should be collected by school divisions. The health information number, there's actually specific legislation that it's only to be used for the provision of health services. There is a section in the forms that can be filled out and sent to the ministry that puts the that you can input it in. That would be for the exceptional circumstance, and I have trouble thinking of one where that would be needed. The question itself answered itself, that in most cases we don't need it. The very odd time it might be needed, the only example I have ever thought of is if there's a team is traveling to another province where it's thought that they might need that number to have handy to if they need emergency help. But in most places in Canada, at least, you'll get the emergency help and provide the data later. So no, there's we've had some consultations about this, but basically speaking, no, we should not be collecting those numbers. If there's a good reason to collect it, you can save the information, but no, it should not be collected.
Can I add something onto that? We just lived through a little bit of that. So we've been working with Geraldine last summer when it came to light that we should not be collecting the HSN at Prairie Spirit on our registration form. And we went through a data sharing agreement with Health, and they've asked us to continue collecting it because they would like it very much for immunization purposes from the educational system. So we worked out an arrangement where we collect it on registration, but no one can view it. It only goes to Health, and no admin assistant can view it, no principal can view it. So that's the change that happened for us last summer. And then we did have some staff contact us saying, what about field trips? You know, I need no, you don't. In Saskatchewan, you can go to the hospital, don't need your card with. And if you're going out of province, that might be a time to collect it just for that moment and then have it destroyed, you know, immediately after.
And Clint's point about data sharing agreements, very specific ability to do that would cover how that data is used, would cover the consent of the people providing the data. They'd know how it was being used. So that's a very specific exception. Sorry, Rob, I think you.
I was also going to say, this is probably something that gives Clint and Geraldine sleepless nights in terms of when a school year begins, that forms that were used in the past are just taken out and let's reuse them. And there's an obligation, and this is part of the evolution of what information do we really need and for what purpose is it being collected. So this might have served a purpose in the past, might have been a practice in the past, but today, what is the need and purpose? And I think it's been wonderfully provided an answer there by Geraldine and Clint. So.
Okay, the next question. Is there limitation in terms of a student's age when speaking to the child's privacy and the parent's right to know?
No. The quick answer is no. There's no age limitation. If they're under 18, it applies. You could have, for example, a 7-year-old that's seeing a school counselor and there's notes made of a counseling session where the child talks about some parental issues or something, and it's significant, and it's deemed that, whoa, if the parent knew about this, that would really be an invasion of the student's privacy. There's some case law talking about how it's important that kids have trust in a counselor. That could happen at a very young age. So there's no limit. However, generally speaking, the older the child is, the more likely it is to be an invasion of their privacy. Generally speaking, young kids, 5, 6, you know, you're sharing stuff with parents because the parents, and in most cases, parents have the best interests of their child at heart. But as you get older, then kids start having some independent issues and things. So it's an analysis of each individual child. There's no specific age or issue limit, but it's a really look at that particular child's privacy.
The next question, is there an age at which students can and cannot control their own information?
Generally speaking, it's when a child, and this is for anything in law, whether you're going to get a medical treatment, the courts will look at the factors of whether or not the child is mature enough to understand the nature of the issue, the consequences of any decision that's being made. Once a child's of that age, then they can start making their own individual decisions. Children of 12 can refuse cancer treatment, for example. Children of 14 or whatever, you know, they can have birth control, whether their parents like it or not. So if we look at the medical analogy and transfer that to a sharing of information analogy, similar things would apply. So it's about the maturity of students. We generally say once they're in high school, we really have to carefully consider their wishes. As it doesn't mean we can't share anything with the parents, but it does mean we have to look at whether it's an invasion of their privacy. And this is not the 14-year-old guy that says, "Ha, Mom, I'm going to tell them not to give you my report card." We're not talking about that kind of sort of immature assessment. We're talking about a thoughtful process. So.
Next question, is there a recommended virtual platform, Teams, PEXIP, Zoom, we should be using?
That sounds like a Clint question. And you don't have to give a recommendation, but
It could be any of those. In our school division, we have set both Teams and Google Meet to level 1. We work with our partners there to achieve that. But we could have done the same with Zoom. We haven't. They're level 2, so you'd have to follow the rules around level 2 in our organization. But it's going through the right processes with your IT department and then understanding those as a staff and when you're using them.
I think that's similar to the legal advice we've given to boards. It's not what you use, it's what you look at in the criteria and what the settings are at and how it's going to be used.
Yeah. Next question. If the police phone the school to confirm the attendance of a student who has been reported missing by the parent, can you share that they are at school and safe with the police?
Probably yes. We'd have a discussion there. Now, the police are not, depending if the police are in an investigation and request the information, that's the criteria that are set for the sharing of information with the police. The safety issue, as Clint had mentioned before, is very significant. If the safety of the child is dependent upon being able to locate the child and know where they are, that may be something that would give us sufficient ability to do that. There's a general section of 28 that allows sharing of personal information where the general public interest outweighs the privacy interest. So that may be a situation there. If the police are involved, and what are they going to use the information for? Are they going to share it with the parent? Is there are we aware that the parent may be harming the child if they know they're at the school? A lot of factors will go in. Again, in each of these situations, it's an individual assessment of the particular factors for that child. And the safety is most important in dealing with that. So we probably would, but we may not. A typical lawyer answer, it depends.
Next question. Does a staff member ever have the right to share a clinical diagnosis or medical interventions, examples drugs, therapy, of a child with other staff members without verbal or written consent of one or both parents or guardians?
This is a little bit away from this, but the school division owns, and that's the concept that's used in law, owns all the records that are created for the school division. So when we're talking about LA FOIP, we're talking about records, which is the written documents. We always suggest that you use similar principles for verbal documentation, for verbal information as well. For a written document, once it comes to the school, it is owned by the school division, and the school division has the obligation to ensure that that is used in accordance with LA FOIP. Therefore, if this one staff member needs to share it, the need to know principle comes into play, then the school division can say, yes, it shall be shared. So once it's within that school division control, the policies, procedures of the school division and the need to know principle will apply. So the staff may or may not be able to share it depending on the need to know. And it's the staff member can make that decision if they have the capacity to do that from their position, or they may have to go to their supervisor, and that will have to be done in accordance with school division policy.
Next question. Do information sharing agreements come into play, perhaps to make sharing information easier, but still within legislation?
Clint, you can maybe comment on that.
Thanks, Geraldine. Yes, we use an information sharing agreement with health. We have done so for as long as I can remember. We also will occasionally share information with justice, and we will usually write up an agreement at that time specific to the case, whereas the one in health is broad and is annual. But we review it each year and make it match the current situation, like the HSNs that I just shared that we modified this last summer.
Rob, I think from the provincial level, there's some agreements in place too as well, I think.
There are numerous agreements. Thank you, Geraldine. You're right. So it's incumbent, I think, just as was referenced earlier, you look at it annually, and does it still meet the purpose and the intent that was originally desired? Education has connections, I'll call them, with other ministries, with Ministry of Health, Ministry of Social Services, Ministry of Justice and Corrections. And so it's incumbent upon ensuring that those agreements are up to date, current, and that everybody's understanding of what in fact is in those agreements.
And there's some pieces in the regulations for certain types of agreements, and there's also good information available on the websites about those kind of things. And just before we leave, I'm just going to tell the one other website that we've worked on with our education partners, sassschoolsprivacy.com. It's a useful website for school divisions. We've been trying to keep it up to date. Mostly the information there is good and solid. We just trying to add more information all the time, but it's a good basic understanding to, if you want a quick look at a question, to go there and check on that. Yeah, SAS Schools Privacy. Great, thank you for putting that up.
I was just going to reference it as
Oh,
well,
that's great.
because you can get a privacy impact assessment template off of this site. And it's really recommended anytime you do anything from a data sharing agreement to putting video cameras in your school, that you first do that impact assessment to see how it will impact privacy and whether or not there's ways to do things differently before you decide to do it the way you're going to do it.
So that was the last question we had. And I just wanted to thank Clint, Rob, and Geraldine for being presenters. Today, it was a great session, and I think that our audience really appreciated you coming out and sharing your wealth of knowledge with us. So thank you for the audience participation as well. And we would ask you to please complete the post-webinar survey, which will pop up once you leave the webinar. And the feedback's really important to us so that we can develop future webinars based upon what you want to hear about, what you want to see, what works and what doesn't work. So again, thank you very much, and enjoy the rest of your day.
Thank you.
Thank you. Thanks for
you.
organizing this. Yeah, and you, Rob and Clint, this was good. Thank you.
Thanks, Geraldine and Rob.
Same.
Well.